Hello, good evening, one and all. Here I am going to explain about the few concepts of company law, that is notice, agenda, proxy, and quorum. So let's start. What do you understand by the word notice? Notice is very simple. Whenever you are going to conduct any meeting for the organization, it is very important that you have to give them a prior intimation about what is the meeting about. Prior intimation in the sense 21 days before you have to provide them with the proper notice in writing or in the electronic mode in any, as the case may be. So 21 days before you shall inform to all the members that what is the meeting about, okay, and what are the points you want to discuss in the meeting. Provided the general meeting may be called shorter as well, but in that case you have to make sure that if that consent is being taken by all the members in writing and in the electronic mode. So very simple, whatever the things you want to discuss in the meeting, prior intimation shall be given. So there are certain provisions related to the notice. What are these? In case of any annual general meeting, by 95% of the members shall have the right to vote. That is the first clause. And whenever we talk about the topic notice, it is very important that notice also again in turn is divided into two parts. The company is having which is having the share capital, and the company which is not having the share capital. So here the company which is having the share capital, in that case also majority of the members, that is not less than 95% of the paid up capital of the members, shall have the right to vote. Same case goes with the company which is not having the share capital as well. There also not less than 95% of the people shall have the right to vote. So that is the case. So every notice of the meeting compulsory it should have it should contain the details like at what place they are conducting, at what date, at what time, and what hour shall be clearly mentioned, so that the people who want to attend the meeting will not have any dilemma regarding the meeting. So they will be very clear that at which date, at which time, at which hour they are supposed to be present, and what are they going to discuss in the meeting. Means what are the transactions which they are supposed to discuss in the meeting, that also shall be clearly mentioned in the notice. So notice of every meeting of the company shall be given to every member of the company, the legal representatives of any deceased members, or the assignee of any insolvent members, auditors, every director of the company. That is mandatory. So whenever you are preparing any notice, it's very important that you shall give to every members of the company, auditors of the company, who are the main managerial positions of the company. Compulsory you have to give it to them. So in case any accidental omission has been happened in the notice, no problem, by any other member or by any other person who is entitled to, who received such notice. For example, in case by mistake, if you have not mentioned anything in the notice, the person who is supposed to receive that notice, he shall put the objection stating that whatever the points you have discussed in the meeting, it's invalidate. So he might raise the objection. So make sure that you don't make any mistakes in the notice. So this is all about notice. Now next go to agenda. What do you mean by agenda? Agenda is very simple. The first always, whenever we talk about the company law, first always it comes the notice. After notice, in the notice you have to mention what are the points you want to discuss. The agenda of the meeting. Agenda is very simple, the list of the topics or list of the matters that you want to discuss in the meeting. So an agenda is very crucial for discussing the things. An agenda should always be in a systematic manner. An agenda is always very crucial for conducting the business meeting in the structured manner. Because if you don't have proper planning, if you don't have proper systematic planning, systematic approach, then you may miss out some points in the meeting. So it's very important that you have to list out the things that what are you going to supposed to speak. That is very, very important, so that you will not have any confusion, any dilemma, and you will not miss out any important point. So every member who is qualified to attend the meeting gets the agenda as well as the notice of the meeting. So those people who are qualified to attend the meeting, compulsory they will get the prior notice about the meeting, and they will also have a clear-cut idea about what are they going to speak in the meeting. Okay, so that they will not have any confusion, any type of perplexed situation in the meeting. So agenda must be followed very exactly. See, whatever the points you have mentioned in the notice, and whatever the points which have been discussed in the notice, and whatever the points which have been discussed in the agenda shall follow exactly after the discussion as well. Okay, so after the discussion also you have to put it in the paper and you have to follow it, implement it. Very important. Order of the agenda discussed in the meeting can be changed. See, whatever the points you have discussed in the meeting, it can be changed with the approval of all the members present at the meeting. So this is what agenda means. Agenda means very simple, the list of the topics that you want to discuss in the meeting. That's it. The next comes the quorum. Quorum is quorum. What do you mean by quorum? Quorum is nothing but the members who are going to supposed to be present in the meeting. The minimum numbers whose presence is required in the meeting. So, according to the Companies Act 2013, it states that a company established under this act, whenever they are holding any general meetings, any board meetings, any AGMs, any extraordinary general meeting, it is very important that they have to follow the rules and regulations of the Companies Act. Means whenever they are going to whenever they are going to go for the meetings, it is very important that minimum members shall be present in the meeting. So quorum is very simple, the minimum number of members that are supposed to be present in the meeting, whether it can be a general meeting, board meeting, or extraordinary meeting. Why is it like that? The main logic is that minimum members at least two, because with one person we cannot conduct the meeting, we cannot generate ideas, it's highly impossible. So there has to be some at least 2 to 3 people so that we can discuss the ideas and implement it. So that is what quorum means. So now the question will arise, for which companies how much quorum has to be present. So quorum required for the general meeting as per the section 103. Quorum required for the general meeting in case if it is a public company, the public company who is having 1000 members. If 1000 members are there, in that 1000 members at least 5 people should be present at the meeting. If the company is having 5000 members, at least 15 members should be present for the meeting. More than that also, it's very good. In case if it is 5000 members or more than 5000 members, then 30 members should be present in the meeting. So it depends upon the count of the number of members of the company. Okay, so that is mandatory. So this is for the public. Now let's see for the private. In case of the private company, regardless of number of members, 2 members compulsory they should be present for the meeting. Okay, so this is a quorum for public and private. Very simple. For the public companies, minimum 5 people shall compulsory be there. For the private people, minimum 2 members for the meeting. It's very simple, so that if you have minimum number of required members present in the meeting, it shall be very easy for us also to discuss the things, to analyze the things, and come to a consensus and come to a conclusion or resolution for the meeting. That is the only logic behind the quorum. And the last the day of the topic is the proxy. As you already know, proxy is the word which is used very often, even in the colleges. We say no, don't give proxy attendance. Proxy means what? Proxy means very simple. In the place of the main member, you are sending an alternate member to attend the meeting. That's it. Proxy means an instrument in writing signed by the member. Suppose if I am the member of the organization and I am not able to attend the meeting, so on behalf of me, my proxy, my other person will attend the meeting. Okay, so I have to put it in writing stating that I am not able to attend the meeting for today. So on behalf of me, I am sending some other person on my behalf who will attend the meeting, as well as on behalf of me, he'll vote for the meeting as well. So that is what proxy means. So let's see according to the law language. What do you mean by proxy? One who is authorized to act as a substitute for the main member, who has a right to vote in the meeting. The grant of authority is also given by the main member. Okay, so but it has to be put it in writing, as you are seeing in the picture. The proxies are going for the voting. Okay, so a person who attends the meeting and vote in the general meeting on behalf of the main member of the company, they is called as proxy. But a proxy has certain provisions also attached to it. Let's see what are the provisions which are given by the company law. Proxy shall not have the right to speak in any meetings. What are the provisions relating to the proxy? Means what are the clauses which are related to the proxy? The proxy, whoever is attending the meeting, shall not have the right to speak at the meeting. He is only entitled for the voting. Okay, unless and until it is mentioned in the Articles of Association, otherwise the proxies cannot be appointed for the companies who are not having any share capital. Very sad. The companies which don't have any share capital shall not appoint any proxies. Okay. And one more clause is the central government may also prescribe a class or the classes of companies where the member shall not be entitled to appoint any other person as a proxy. So central government also, it has put certain pressure on one class or a certain classes of companies where they cannot appoint the proxy, provided the person appointed as a proxy shall act on behalf of such member or number of members not exceeding 50. Okay, so the proxy can be act only on behalf of member only when the minimum number of people at least should be 50 in their company. Okay, so every notice calling a meeting of the company which has share capital or articles which provide for voting be proxy at the meeting, there shall be apply or appear with a reasonable prominence. A statement has to be given. Okay, that this person is going to be appointed as a proxy and would be only entitled to right to vote, not to speak. Okay, or where that sometimes it is allowed to go for 2 or more proxies as well. Okay, and vote only instead of himself. The proxy need not be any member of the organization, it can be an outsider. If default is made in compliance with the section 2, then every officer of the company who is in default shall be liable to pay the penalty of 5,000 rupees, punishable with the fine and extent to 5,000 rupees. Okay, so any provision contained in the articles of association which clearly specifies about the longer period than 48 hours before a meeting of the company for depositing within the company or any other person any instrument appointing a proxy. Very simple, I'll put it in the simple words. If I am not able to attend the meeting, I have to give prior 48 hours before prior intimation, and that 48 hours prior person has to go to the organization, go for the appointment of the proxy. So this should happen within 48 hours. Okay, so for any other purpose of attending the meeting, invitations to appoint as a proxy as a person or one of the member of the person specified in invitations are issued at the company's expense to any member entitled to have a notice of the meeting sent to him and to vote thread by proxy. Okay, so that is the case. Every officer of the member who issues a notification shall permit their issue shall be liable to penalty for 5,000 rupees. Who knowingly issues the invitation has foresight or willfully authorizes or permits their issue shall be punishable with the fine of up to 1 lakh rupees. So, provided that the officer shall not be liable punishable under this section. Okay, so issue of proxies appointment shall always be in writing. That is mandatory. Be signed by the appointer or the attorney duly authorized in writing. If the appointer is a body corporate, make sure that he has a seal and sign. Very simple. The person, if I am the member of the organization, I have to make sure that it is put it in writing. If I am one of the board member, one of the body corporate, make sure it is in proper common seal and sign. Otherwise, you shall the person whoever is appointing as a proxy shall also be liable for the fine, and even the company members as well. The instrument appointing a proxy in the form may be prescribed very clearly and shall not be questioned on the grounds that if fails to comply with any of the special requirements specified for such requirement instrument by the articles of the company. So appointment of the proxy also, the form has to be clearly filled. It is already prescribed. Failing to that, they will be punishable. Okay, and this particular specified for such instrument by the articles of association from 2014 itself. So this point also it is clearly mentioned in the articles of association of the company. Every member entitled to vote at a meeting of the company or on any resolution to be moved that shall be entitled during the beginning for 24 hours before the time is fixed for the commencement of the meeting and ending with the conclusion of the meeting, to inspect the proxies lodged at any time during the business hours, provided not less than 3 days notice in writing of intention so to inspect into the company. So yes, every member who is entitled to vote at the meeting shall go for the meeting within 24 hours before the time is fixed, and make sure that they end at the business hours, and the proxy's appointment also it should be within 48 hours. So everything, the documentation part, everything has to be done. Okay, so these are the legal rules regarding the proxy, regarding the notice, agenda, and quorum. Thank you all, and all the best.